Since time immemorial, indigenous people have lived, traveled, and traded in the Puget Sound region. The Donation Land Act of 1850, to encourage westward expansion, allowed American settlers to claim these traditional native lands. The explosion of immigration into the region that followed forced the U.S. government into a fraught treaty-making process with local tribes. The original terms of the Medicine Creek Treaty were inadequate and ultimately unaccepted by tribal leaders, resulting in war. The Indigenous Voices podcast is an extension of the award-winning Puget Sound Treaty War Panel series and Fort Nisqually Living History Museum. The podcast advances tribal voices in the telling of Puget Sound history and shares tribal knowledge and expertise with wider audiences. Hello, my name is Warren KingGeorge. I'm an enrolled member of the Muckleshoot Indian tribe on my father's side, and on my mother's side, I descend from the Upper Skagit tribe.
Nettsie Bullchild, Nisqually Indian tribe, Director of Archives and Tribal Historic Preservation Office, tribal member, and tribal elder.
Haslachel, Togalapo, Deisha, Desiyaya Chullup, Brandon Reynon Titsta, Spalapups Chud, Duflalut Debati, Director/THPO. My name is Brandon Reynon. Welcome. I am the Director and THPO for the Puyallup Tribe of Indians. I'm also a Puyallup tribal member.
Haslachel, Takablu Sitsta, Puyallup Chud. Good day. My name is Takablu. I'm from the Puyallup tribe. My English name is Amber Taylor. I am the daughter of Eric Bennett and Carol Taylor, the granddaughter of Ramona Bennett, Clyde Bill, Patricia Taylor, and Al Taylor.
The Boldt Decision of 1970 upended the fishing industry in Washington state, resulting in a slew of court cases over the next 5 decades. In Episode 11, participants discuss a selection of court cases covering shellfish, large game, and habitat restoration.
The Rafidi case is actually really interesting. So this, pulling back into the Medicine Creek Treaty, this one had to do with shellfish. And in the treaty, it states that the Medicine Creek Treaty tribes had rights in common reserved to the shellfish, right? To the shellfish beds, except for the ones that were staked and claimed by, or staked or cultivated by citizens, or those that were set aside for non-Indian cultivation. So this case came in, and what's really interesting is that Rafidi had written, which I think is fabulous, that he had this foresight in 1994. He says in his decision, a treaty is not a grant of rights to the Indians, but a grant of rights from them. And I think that's such a powerful statement in his decision, adding that the U.S. government made a promise to the tribes in the treaties that they would have permanent right to fish as they had always done. And so really in the Boldt decision, it ruled that all public and private tidelands within the case area are subject to treaty harvest, except for those that had private claims. So I think this is a pretty interesting decision that he made, but I just think that's such a powerful statement that it wasn't a grant of rights, but rather a grant of rights from us. It wasn't that anything was given to us, right? As so many people say, oh, you've been given this, you've been given that. It was that we extended the right to everyone else as well.
It seems like on these cases where it's fishing shellfish, they're always trying to insert off reservation. They're trying to make that issue because they don't want the tribes to have, it always goes into court that, you're talking about an off reservation, which would have been, these private landowners or whatever, where they considered those beds being staked. But, that's what it always seems to, is to get their case there. They're always referring to off reservation. But like I said, they never look into that. This is ancestral territory, land.
Right, Nettsie, that's a strategy right on their end, is to put in some verbiage that has these limitations or has these conditions, and I think that's a key. Like most of our treaties, they have some key phrases and key wording in them, some syntax that's real. I mean, you've got to read it carefully. You can't just skim over it, and that's part of it. And I truly believe that's part of the strategy, and it's on purpose, right? By our the people who are bringing these court cases, who are filing for these court cases. And it's linked indirectly or directly to that conversation we had earlier about these agreements from the 1980s, 1988, where some of these developers and some of these big business, Port of Seattle, Port of Tacoma, even these marinas were trying to establish themselves and try to be almost like consider themselves exempt from treaty rights, from having to deal or work with or work around incorporate treaty rights into their businesses or into their into their daily what do you call it, best management practices. I mean, we've already the Centennial Accord kind of refers to this a little bit, that the tone has been set by the United States Supreme Court in 1979. Boldt set the tone in 74. The U.S. Supreme Court pretty much solidified that tone in 79. And so the state recognized that, geez, the tribes have a lot of authority. Precedence has been set in 74 and in 79. I mean, if we try to go to court with a federally recognized tribe over natural resources, we're going to lose. We're going to need to work with the tribes from this day forward. And that, in a sense, is another way to sum up what the Centennial Accord was about, to prevent court cases or to minimize court cases so that we can move forward in the best way possible concerning natural resources. So, Netsie's right. There's some phrases and they still do it today, even in 2024, when processing your vote, when you're going through your voter's pamphlet, you've got to read every single detail before you fill in the box and submit your voter's pamphlet, because it can be tricky. You almost have to be a lawyer. You almost have to have a background in legalese in order to decipher some of these words and phrases and how they're being used. But I agree. There's some tricky words that are being tossed around in some of our discussions.
And in that it says, if we all got back to that, it's supposed to be usual and custom. That's what it says. But they interpret usual and custom as whatever they want, and then, like I said, then they throw in this off reservation, and it's like there was no reservation before the usual and custom. That's why I said I'm always telling my council, you always use ancestral lands. They're go back way further than traditional, because that ancestral covers everything. But I mean, it states right there usual and custom, so they interpret usual and custom as what they want.
No, and that's it, Nettsie. That sums up. That's how we as tribes, that verifies why we have an interest in not just that location where that marina is being developed, but all the water that flows through that marina, because of our usual and accustomed area, our U&A. That's why we have that, and that's been settled. It's been established, well established, and there's no going back on that. There's no way to reverse that. That's one of those big one of our assets that we have, and we're never going to give that up. Our usual and custom areas.
Do you know that we have, like here at Puyallup, we have our own shellfish management department or division that manages shellfish, and Geoduck and geoduck quota is included in that. And then we also have the ability to, gather or harvest shellfish in different ancestral areas. I know my dad for quite a few years was the director of the shellfish. It's Nancy Shippentower is the director of our shellfish department now, and oversees that. But we do have, we get a quota, and our divers dive out here in the Puget Sound in our region. Yeah, so it's kind of the same thing, hunting, and then we have fisheries and shellfish management. So those are 3 programs that run, and I'm sure if you guys have shellfish also, then same thing. So we do manage our own resources.
And one of the things for Nisqually has been, and I, my nieces are Puyallup, Brandon. So, but it's opened up that next generation. Where our fishing has dwindled. This next generation, like my nieces, and a lot of the younger ones, do geoduck. They became divers, and they go out and do that. So it's helped that generation from what I guess you'd say mine and my dad's generation always depended on. They didn't do. We just went and dug clams or oysters. We never sold, but it's helped the younger generation to go into this new path of, because there's not enough fish left and places to go. So it's really taking care of them, with what they've had to learn. And I think in that process, it helps them to understand all the natural resources that need to be protected, why they need to be protected, why it's important. So it's not just like we're trying to teach them something. They're actually going out and saying, oh yeah, that's really important, like climate change and all of that. So I think it's a benefit to tribes that these younger generations have gotten into that part of it to help support that.
So although the tribe does have saltwater fishing rights in Elliott Bay specifically, most or all of the beaches within Elliott Bay are polluted or inaccessible. And there were some major changes to the landscape by the city of Seattle to the beaches and the delta of the Duwamish River. So a majority of our usual or our historical mud flats, delta, tide flats have been filled in or developed or both. And so really limited on beach access, beach food access. To mitigate this, the tribe invested into some property on Vashon Island. And from what I understand, it's about 100 acres, and it's actually part of Vashon Island's watershed. So a portion of Vashon's drinking water comes from this watershed. And so the tribe now owns it and is in trust. The property is in trust, but we'll never develop it. We'll keep it as is, and we'll do that because we're stewards of the land, right? We've established that in our podcast early on that all tribes basically are official stewards of all the land that they live on and live nearby. And so as stewards, we're concerned about water quantity, water quality. And it's no different with saltwater, with our beaches. And so because a lot of our ancestors have ties to saltwater villages, it just made a lot of sense for the tribe to invest in Vashon property and on saltwater property, so that we can not only have access to native and wild shellfish, but also establish a shellfish program where we can grow our own seafood and use this program to deliver fresh seafood to our elders and to our disabled and to our single parent mothers, but at the same time also open it up to our tribal membership who have the resources and have a vehicle and have the resources to to pay for the ferry fee to get across, and can afford to take a day off, or to spend a Saturday or a Sunday over on Vashon Island digging fresh food, traditional food. So this is a great investment from my perspective as a tribal member. Real savvy move.
Donald Buchanan, a member of the Nooksack Indian tribe and resident of Kent, Washington, was apprehended by Department of Fish and Wildlife enforcement officers in 1995 while hunting in the state-owned Oak Creek Wildlife Area. He was found with 2 recently killed 5-point branch antlered bulk elks at a time when the Washington state hunting license had been revoked and the state elk hunting season was closed. Buchanan claimed a treaty right to hunt in the Oak Creek area, asserting that this right could not be restricted by state hunting regulations. He was charged with 2 felony accounts of possessing big game during a closed season and one misdemeanor count of hunting while a license is revoked. The trial court dismissed the charges, finding in favor of Buchanan's treaty rights, a decision that was affirmed by the Court of Appeals. The state challenged this conclusion, questioning the scope of the hunting right, and whether such treaty rights were abrogated upon Washington's admission to the Union. So it went back to 1889.
They were trying to charge this Nooksack with hunting. He had to go to court, and it's again saying, well, this is not your reservation lands. You're off reservation. You shouldn't be hunting. And, fight was the same things, but this was our territory. This was ancestral land that we used to hunt before it became this park. And then that one got into, I think at the time of it, got into the non-federally recognized issue also. So that's some of the stuff they were trying to bring up in the court. So it was a Nooksack that was hunting and killed some elk in a park. And, under the treaty, it's supposed to, I think it says unclaimed lands, you hunt in unclaimed and open lands, but it's that determination, it was a park that's set aside. But it gets back to, if this is your ancestral hunting, because I think a lot of those cases with hunting happened, in parks, because that's where they used to hunt, so it's like, what are you supposed to do? But, because they try to say it's not reservation, that wasn't how it was back then.
That's basically the fishing case all over again, but we're dealing with ungulates. We're dealing with deer and elk, right? Our 4-legged, right? So once again, setting precedents. I don't think there's much of a case at all. You can, because it seems like we've already been through this. This is just the same concern or the same question, and it's dealing with wildlife instead of salmon.
I think it's important too to point out that the treaty rights that we're talking about, and we've already hinted on it in this episode and past episodes, these are rights given, that we've had since the creation. And that's when we think about, Warren has hit on it, our brothers and sisters who are the clam, and then our 4-legged ancestors who are, in this case, the elk. Our creation story talks about how each of these animals were created from people, and they were given, in our creation story, they chose to become these species, and using modern scientific terms, to give us nutrients. And so when you think about how the state was saying Mr. Buchanan didn't have the right, he asserted his right as a tribal member whose ancestors had been hunting this same relative since the creation, not since 1889, not since 1854 or 1853, for instance, before the treaty. His ancestors have been hunting since the creation of this world, because that's what they chose to be. So he was honoring this elk, or these elks, these 5 elks, or however many elks he hunted, and he was doing it to feed his family. And it wasn't for financial gain; it was for sustenance. Something that our people, whether it be Puyallup, Nisqually, Nooksack, Lummi, Quinault, we've all done that, and we're doing it today. And the the courts agreed that, yeah, he's right. He has the right. And that was, we have the right to fish whenever we need to fish for food. That's a right that we have as tribal members. And it goes well before any treaty.
The other thing is, how did he know to go where he went to get these elk? It's because he's been going there probably since his family showed him where to go. A lot of them go with their fathers or grandfathers. They know where to find them and they know where to go. So it's evident he was there for a reason. He wasn't just, looking around trying to find someplace, but he knew where to go. And, in those, like I said, these hunting places. So that's why he was there.
Yeah, the culvert case was filed initially in 2001, and it involved fish passage blocking culverts under roads owned by the state of Washington. The United States and a group of tribes filed suit seeking an injunction requiring the state to repair culverts under its control to restore access of fish, including salmon and steelhead, to more than 1,000 miles of upstream habitat. Restoring passage is expected to result in production of several 100,000 more adult fish annually. And that'll be a significant boost, it says, for the state's ailing salmon runs and for those who depend on the runs. Mm-hmm. So that was kind of when they first filed this case in 2001. It was because the culverts really were blocking passage for salmon. And let's see, I can't remember. I think it was... So 2013 is when U.S. District Court Judge Martinez found for the tribes and ordered that the culverts be repaired. And this was a huge deal because it's really expensive. I can remember when this ruling came out, it's really expensive to repair all of the culverts. So you think of, the pipes that run under the roadway where water runoff comes. Having to repair and replace those across an entire state is not a cheap thing to do. And so that was one of the issues with this, was the huge expense.
Yeah, they were given federal money to do it, to get us corrected. And the over 800 culverts had to be replaced. And as of 2024, 146 have been completed. So a lot of ways to go. And there's also something, these culverts come across each of our desks as well on a regular basis. That's something we, the issue was it impeded, fish passageways. And so when it's an effort to restore. Goes back to our last couple episodes we've been talking about it, how the tribe said you can't block these passageways. You're taking 12 feet of creek, creating a pipe that's 6 inches wide, and now you're wondering where the salmon have gone. You've eliminated their habitat. You've eliminated their way of spawning. And so this was a response again once the state and the federal government said, you're right, tribes, once again, you were correct, and we are going to go and fix these. But then they realized it's 800 culverts within, and these all got to be coming from a few inches all to feet wide, sometimes up to 20 to 30 feet wide, or, they're having these 24-foot diameter pipes that they got. So they became a real problem real fast, but not our problem. It's the state's problem, and they have to fix it because they've realized the salmon and the water in general is something that's very important. The federal government finally realized, wait, water is important. We can't live without it. We should probably do something about it and fix it. So,
and it also says that they granted the tribe's request for a permanent injunction so that they would get this done, and that they had 3 options to achieve passage, which avoid the need for the road to cross the stream, a full span bridge, and a stream simulation culvert. So they did have requirements on these too also once they got this through, that these are some of the things they have to abide by, mandated.
And I'd just like to add that this also verifies that once again, we're not just talking about a specific location, a specific village site. We're talking about miles and miles and miles of critical habitat for salmon. Um, this is just one factor involved in this is what helped um, de- uh, uh, decrease our salmon runs. Um, if you, I mean, I got to grow up. I was really lucky that my late father was adamant about bringing me outdoors and taking me trout fishing in all the creeks on above White River. So I got to know those streams, those tributaries intimately, virtually every weekend during the spring and summer. That's what we would be doing in the 70s and even into the early 80s. We'd be trout fishing in those creeks, catching cutthroat trout and brook trout and steelhead. And so I got to see those culverts firsthand, and I remember those culverts. They created some of them were not even functioning as a culvert. They were just these empty tubes, while the creek would when it passed underneath the roadway, it would go to the left or the right or even underneath the culvert. So these culverts were dysfunctional. They weren't even doing what they were designed to do. And so I get this concern. I mean, I totally get it that once again the tribes being stewards of the land and stewards of the resources, saying, hey, these salmon need help. We need help getting these salmon to their spawning habitat, and these culverts are impeding. They're uh, they're preventing the salmon from accessing their spawning grounds. So I can't believe that we had to actually go to court, that the United States government had to file with the state of Washington to convince them that this was the right thing to do. I mean, it just blows me away. It's criminal, is what it is, and that's what this turned out to be. Right? They were wrong, and so and it's still not done yet. That was 2001. You heard Brandon say there's still culverts yet that have not been addressed. And you hear, I mean, we as Native Americans and some of our memberships who are still active fishermen, I'm sure they still hear about it. I'm sure we still hear about it. I mean, I still hear about it I'm a retired fisherman, and I still hear comments and questions about how the Indians are taking too much fish because there's no fish to be caught. This is just one factor that you don't get to hear about very often, and I just wish that there was a more education. You heard it before. This is one element of the education process where people need to be more informed about what the tribes really have done here and what we're doing, what we continue to do on behalf of the natural resources. I mean, even though you hear the term treaty rights, it's the same thing. They're natural resources. We're doing our best, and oftentimes we have to force our co-managers into a corner to do the right thing, and oftentimes that's what happens. And the culvert case is no different. Essentially, we were just saying that something has to be done about these impediments that they're preventing the salmon, not tribal salmon, not treaty salmon. They're preventing the salmon from spawning.
And we get back to that, how others could benefit from the treaty. And this is one of them. But it's always like, why do the tribes have to bring it up? The state has biologists. The state has all of these people in their departments that should be identifying this. But, what goes to the news is like, oh, here's the tribes, going to court again, complaining about something, but they're not realizing it. Like Lauren said, it's benefiting everybody. It's not just benefiting the tribes. But so why aren't they doing their part to, take care of this, why does it always end up the tribes have to tend to it?
So an interesting, that is so true, Nettsie. Absolutely true. Another interesting thing that I just kind of digging around while I'm listening in, I think it's funny that WashDOT on their page about culverts, giving information about what is this whole culvert, what's the deal with it, the injunction for fish passage. And it says, how do we know it's working? We monitor the barrier correction post-project to verify structures are fish passable and function as designed. The Department of Fish and Wildlife conducts surveys upstream to look for adult salmon and steelhead use. They found fish spawning upstream at over half of our fish passage projects constructed in the most recent years. In some cases, it may take years before they use the new habitat. But I mean, I think that is like, that says it all. Like over half of their projects, they have found fish returning upstream. And yes, it does take a couple of years. You can see what happens when these dams are removed, how, they have to relearn. Our salmon are incredibly intelligent, and they are, they come back to their spawning place that's the life cycle. They come out to the sea, then they come back up, they spawn, and that's where they die. And that's where the next generation is born. And it's the same thing. And so when you get into blocking and creating these obstructions, they're unable to make their way back to their spawning grounds. And that they're just, salmon are so incredible. And kind of, what Nettsie was talking about in terms of, why do we have to? And this is really benefiting everyone. And you think of the Pacific Northwest, what do you think of? You think of beautiful forestry, green, you think of the rain, you think of our beautiful mountain, and you think of salmon and seafood. I mean, it's part of who all of us are now. And so people really should appreciate the fact that the tribes do have this treaty to continue to protect these resources, and they should also really think about being advocates for these treaty rights, to advocate with us, to be to stand up with all of us, because it's really important. Our environment and the natural world around us is important to all of us and all of our future generations.
Hey Shaba, Nisqually, for joining us for the Indigenous Voices podcast. Indigenous Voices is available wherever you get your podcast. Follow and subscribe at fortnisqually.org.
This podcast is generously supported by the Pierce County Historic Preservation Grant,
as well as representatives from Puyallup, Nisqually, Squaxin, and Bullchild.
Music by Vincent Johnson, Nooksack, Lummi, and Nishani Johnson, Jamestown, Sklallam, Lummi.